Welcome to our continuing series of webinars at the Carpenter Law Firm. We're live from the Carpenter Law Firm studios in our offices here in Gilbert, Arizona. The topic today is 2025 enforcement issues. We're going to cover our topic of enforcing the covenants, the rules, and other issues that come up from time to time in Arizona's community associations. Now, just a quick note on terminology. When I say community associations, I mean to be inclusive of condominiums and planned communities. And I'm going to take this from a slightly different perspective today. I thought what I would do is start from the standpoint of what happens if someone were to complain that the association is not doing enforcement. But let's start with what's happening in our state. Well, the legislature is still in session. And of course, we should be fearful of that in a sense. Whenever this legislature is still in session, one never knows what's going to happen. Although last week, the legislature took a vacation, but they're back yesterday, Monday. So the legislature is still in session. We will be doing our annual legislative update in this webinar series on July 15th. So you might make a note of that on your calendar. As of now, the governor has, by way of example, signed Senate Bill 1039, already signed by the governor. Here's what it says. Now, this is verbatim. This is in the statute. If a board records a meeting that is open to the members, this could be a board meeting, it could be a membership meeting. Now, when we say membership meeting, we automatically think of the annual meeting. That is the regular membership meeting. We can, of course, have special membership meetings. The most common special membership meeting off calendar from the regular membership meeting is a special membership meeting to remove directors, or a special membership meeting off calendar from the regular membership meeting to vote on a special assessment. Those are the two most common. If a board records a meeting that is open to the members, the open meeting statute, I almost said open meeting law, but the open meeting law applies to the government, but the open meeting statute for community associations requires that membership meetings be open as well. Verbatim, the new statute, we could call it Senate Bill 1039, but the moment a House bill or Senate bill becomes effective, it's folded into the statute. So the statute will say, if a board records a meeting that is open to the members, the board shall keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request in compliance with section 33-1258, subsection A. That's the condominium version. The planned community statute is the same. The verbiage is the same, copy and paste. So a couple of quick criticisms, which we'll cover again on July 15th, but just to whet your appetite. If the board records a meeting, here's the problem I have. I've been to a lot of board meetings, and let's focus on the board meeting, not the membership meeting. I've been to a lot of board meetings where Tom, the secretary, has a recording device. It's not an iPhone. It's not an Android phone, although it could be. Tom, the secretary, sets it on the table. It's not the board doing the recording. It's Tom. It's Betty, the secretary. And they record it for their own purposes, to ensure accuracy of note-taking, to ensure accuracy of minutes. But the device is not owned by the association. The decision to record is made by Tom or Betty or Phyllis or Mary or Scott or whomever. The device is owned by the director personally. I paid for it with my personal funds. I grabbed it before I left my house for the meeting. I grabbed it before I left my condo unit on the 10th floor to go down to the meeting place on the first floor. And I made the decision. Tom, the secretary, I of course am Scott, but again, just following my point, I made the decision to record the meeting so that I could do a better job with my notes and the minutes later after the meeting's over. The premise of this first clause, up until the comma, is wrong. The board did not record the meeting. Tom did. Phyllis did. Betty did. The board shall keep a copy of the recording. The board doesn't have it. Tom does. Betty does. Phyllis does. In their personal quarters, in their personal home, in their personal unit. Everything in red, the premise is all wrong. You know that. The professional community managers watching this webinar know the board did not record the meeting. The board does not have the data file. Now, there are times where the board does record the meeting. Since the pandemic, the board has used Zoom more often. This webinar is done on Zoom. I'm recording it. I'm doing it on purpose. I'm recording it so that it can go on my website. I know I'm doing it. I'm recording it to the cloud. Some associations do the same thing on purpose. The board is deciding to record the meeting on purpose so that the recording could go on the association's website in exactly the same thought process that I'm using by recording this webinar on Zoom so that the recording could go on my law firm's website. Maybe an association is doing the same thing, but you can see how this legislation, this third bullet point of the PowerPoint, is drafted on the assumption that the board that records the meeting via Zoom is recording it on purpose, and that the board would keep the Zoom recording for at least 6 months and make it available to a member who complies with the books and records statute request in 33-1258 subsection A. You get 10 days to comply with the books and records request. So we end up with this new statute. And you can imagine that if somebody said, well, hey, if somebody wants a copy of the recording, video or audio, it doesn't say, okay, no problem. If the board records a meeting, the board has to keep a copy for 6 months. What I'm stuck on is how many times I've gone to a meeting and the recording is not done intentionally, volitionally, with decision-making by the board as a whole. And what I'm stuck on, obviously, you can tell by the fact that I've been ranting about this for almost 9 minutes, is that somebody comes to the meeting, they're sitting out there in the crowd, and they see Tom, the secretary, place the recording device on the table. And then after the meeting, there's a request pursuant to section 33-1258 subsection A, and the homeowner says to the association, I want a copy of the recording. And the board says, what recording? And the owner says, well, I saw a director record the meeting. And now the board says, well, we don't have it. Maybe somebody on the board has it, maybe Tom has it, but we can't control Tom. We don't own the device. Well, now we're in an argument. And as you know, those arguments don't end well. Now the association's thinking about hiring an attorney. Now we're incurring hourly legal fees to have a no-winner argument with the homeowner under this new statute about whether the board recorded the meeting or whether Tom recorded the meeting. And you can tell from the way I'm explaining this that there's no winner in that argument. Did the board record the meeting or did Tom record the meeting? Nobody's winning there. That's a mess because Tom's on the board. The board probably recorded the meeting. So now we're in the vortex. So we'll do that on July 15th, that plus more, because there's more legislation that's been passed. And there are a few other bills that the governor has signed, but the topic today is enforcement. So let's do what I said, which is start with the end. What happens when an owner says, you haven't enforced the CCNRs? We'll start with the big question. What if we decide we don't want to enforce the CCNRs? Now, as it turns out, this decision is not always made consciously, although it sometimes is. A board decides to decline to enforce the CCNRs, sometimes consciously, sometimes with real awareness. I've had clients before where a homeowner comes along and says, hey, I believe you have an obligation to enforce the CCNRs. And the board's response is, well, we had a vote on that. We voted about 20 years ago as a community. We had a vote at the clubhouse. We had a vote in the park at the annual meeting. And somebody said, hey, let's vote on it. And by a show of hands, the membership voted, let's don't be one of those HOAs that's really a stickler about the covenants, about the CCNRs, or whatever word you want to use. And we decided that we were not going to be one of those HOAs. We decided that we're not going to enforce the CCNRs with vigor. That's my word. But there are associations where the culture is we don't enforce. And they think they're doing the right thing. They think they're doing everybody a favor because high enforcement, intense associations that are aggressive about enforcement create the impression of the big bad HOA. And so when a board makes the conscious decision, we're going to let that slide, whether it's weeds in the front yard or trailers on the side yard or RVs or boats or purple paint or a gazebo in the front yard or any other manner of obvious and big time enforcement problems, whatever scenario you want to create in your mind. There are board members who think, well, we're doing the right thing. We're doing a good thing, I should say, because intense enforcement is irritating and bad for the homeowners. Well, it's bad for the homeowner who's on the receiving end, who doesn't particularly want to receive that. So a homeowner comes along and says, well, I bought into a deed restricted or covenant community, and I have an expectation that I'm not going to be next to a house with 30 violations. You have an obligation to enforce. So we start with the end question. What are the consequences if we as an HOA do not enforce the CCNRs? So let's imagine that there's a lawsuit from an owner styled, that's the caption, who versus whom, John Doe versus Del Boca Vista. I'm a Seinfeld fan. I reference it all the time in my teachings. John Doe versus Del Boca Vista. Now, of course, Del Boca Vista is Jerry's parents' HOA in Florida. There are a couple of episodes about the goings on in Jerry's parents' HOA in Florida, Del Boca Vista Phase 2 Condo Association. I've shortened it for purposes of today. So it's John Doe versus Del Boca Vista. The accusation is, hey, HOA, you owe me covenant enforcement against everybody else but me, but also me. You owe me enforcement of the covenants. That's part of the contract. That's part of the understanding in this community as owners that the association's job is to collect the money, pay the bills, enforce the covenants. That's the deal that we sign up for. So the lawsuit alleges breach of duty for failure to enforce the CC&Rs. The style is John Doe, Scott Carpenter versus Del Boca Vista, breach of duty for failure to enforce the CC&Rs. So the association, upon receipt of that lawsuit, will tender it to its insurance carriers. Let's pause for a moment. What does this word mean, tender? Well, we use the term all the time as lawyers. When I have a client that's sued, I say back to the client, you should tender this to your carriers for defense and indemnity. What do I mean by the word tender? Well, it's actually a very simple term in our world. We don't mean anything complicated by it. What we mean is hand it over to the carriers and simultaneously say, defend me and indemnify me. That's a tender. And you probably don't even have to say anything. Just hand it over and say, I'm an insured, I got sued. That's a tender. You're handing it to the carrier. I'm a State Farm policy holder. I've been a State Farm policy holder my entire adult life. Why am I a State Farm policy holder? Well, like a lot of State Farm policy holders, I have the same reason. My dad was a State Farm guy. If I am involved in a car accident, I call my agent and I say, hey, I was in a car accident. Here are the details. That's a tender. I'm tendering to State Farm, hey, I was in a fender bender in the Safeway parking lot. Please defend me. If I'm sued, hire lawyers to defend me. And if I caused damage from my negligence, please pay for it. That's the indemnity part. Defend me, hire lawyers to defend me if I'm sued, pay the legal fees. And if I lose and I'm determined by a court to have to pay money to somebody else, pay it. That's what indemnity means. Tender to your carriers for defense and indemnity. That's what insurance law means. So you give the lawsuit to your insurance carriers for defense and indemnity. And in this scenario, so far on the screen, we have a lawsuit, Scott Carpenter versus Del Boca Vista, for breach of duty for failure to enforce. I don't want RVs and boats and driveways and weeds and purple paint colors and gazebos and all the other violations around me. I think the association needs to enforce. And by the way, I just bought my house 2 years ago in this hypothetical. I don't care that there was a meeting at the gazebo in the park 20 years ago where everybody voted and raised their hands allegedly and decided we don't want to enforce. That's your story. You can stick with it. But I don't believe that that has anything to do with the law on the topic. I'm suing you anyway in this hypothetical. So the lawsuit is served on the association's statutory agent. And by the way, the statutory agent's role in Arizona has one job: receive a lawsuit that's filed against the nonprofit corporation, serve it on the statutory agent. Once received, the lawyer will say tender to the insurance carriers. The D&O insurance would be the one that would typically respond for defense and indemnity. So what does the case law say on this? We started with the end question. What if we just decide we don't want to enforce because there's friction, homeowners argue, it's expensive, we've got multiple options, but none of them seem to be calibrated to be all that successful? What does the law say? Because we know from attending webinars and other seminars on this topic that none of these options are particularly successful because people are difficult. Nobody really wants to comply. Compliance can be expensive. What does the law say? There's no statute on point that's particularly helpful. Non-compliance is not a crime. The county attorney's office is not going to prosecute the boat in the side yard or the purple paint as a crime. We know it's not a crime. So what does the law say? Well, there are two Arizona cases on point. One is called Johnson v. Point Community Association, and the second is Gefeller. We don't know if we're saying that correctly, but the case is Gefeller versus Scottsdale Vista North Townhomes Association. And these two cases, when read together, say that the association has what we call an affirmative duty to enforce the covenants in a community association, condo and planned community. The association cannot stand by and watch while a covenant violation occurs. When I say covenant, I mean CC&R violation, the boat in the driveway, the side yard, the RV in the side yard, the purple paint, the gazebo in the front yard without architectural approval, fill in the blank, every violation that one could think of. The association has an affirmative duty and obligation to enforce the CC&Rs. The case law is clear. So when the association does not enforce the CC&Rs, that failure gives rise to the lawsuit. Breach of duty for failure to enforce the CC&Rs. It is a lawsuit the association can lose. It is possible for the association to lose that lawsuit. So here's what happens. How can an owner win that lawsuit? Well, our belief as lawyers here at the Carpenter Law Firm is that in order to win, the owner has to essentially litigate two cases. The owner has to litigate whether the association has a duty to enforce. They have to essentially convince a judge that Johnson v. Point Community Association and Gefeller v. Scottsdale Vista North is the legal standard. I mean, the homeowner has to convince the judge that that's the legal standard, and they have to convince the judge that there are violations. Clearly, the owner has to do that. But the owner also has to litigate. By litigate, I mean try the case. They also have to sort of try the HOA's enforcement case. The HOA is obligated to enforce, and if it were to do so, the HOA would win. The homeowner has to try a case within a case, if you will, and I'll kind of show you how that works here in a minute with a hypothetical ripped from the headlines of actual cases I've worked on in my career. The HOA's defense could be, now how does the HOA defend itself? Well, the HOA could say, well, hey, Your Honor, we get it. The owner wants us to take action against their neighbor. But hey, Judge, we've looked at it and we think, we the lawyers for the HOA think that if we were to take action against the neighbor in the manner in which the plaintiff desires, we'd lose. And hey, Judge, that doesn't seem very fair. We believe, Your Honor, that if we were to sue the plaintiff's neighbor over the chickens that are bothering the plaintiff, we'd lose the case. I mean, imagine that. Let's assume a hypothetical that John Doe is suing Del Boca Vista because John Doe is upset about the chickens that are being raised in John Doe's neighbor's backyard. This is my real life. In my home in Gilbert, near Greenfield and Guadalupe, my neighbor has a bunch of chickens and roosters. And there are days when I guess I could decide whether that bothers me or not. Chickens and roosters can be noisy. And if I were the type, I could get out my CCNRs and I could flip through the pages and decide, is this a violation or not? I mean, I'm certainly schooled in the process of figuring out if certain behaviors are violations or not. Now, I haven't done that because I like my neighbors and it's a tolerable amount of noise. But if I were to flip through it and decide that it is a violation, I would have a choice to make. The same choice everybody has in that situation. Do I want to call the management company and be that guy who says, my neighbor's chickens are obnoxious, do something about it, and I demand it. I demand that you do something about my neighbor's chickens. Well, now I've become that guy. Now I've become that neighbor who's asking the management company to do something about the darn chickens on lot 42 or whatever the lot number is. I'm making that up for sake of discussion here today. And now the management company has to go to the board meeting and say, well, there's this homeowner, his name is Scott Carpenter, and I think I know who it is. I think he's an HOA attorney in town, and he's demanding that we do something about the chickens in lot 41 or lot 42 or whatever. And, we got the CCNR provision, and I guess we need to look at it. We need to maybe call the HOA's attorney and have to get an opinion about whether it's a violation or not. And then once we figure out if it's a violation or not, we have to look at our enforcement options and how far we need to take it to satisfy our obligation to enforce the CCNRs. And you see the cascading problem. And I'm not saying anything you don't know. I mean, if you've been at this for very long, that's the basic cascading problem. The domino effect of somebody complaining, is it a violation? And if so, how far do we have to go to satisfy our obligation to enforce? Which we're going to cover. We're not going to just end it with, is it a violation? But how far do we have to take it to satisfy our Johnson v. Point obligation to enforce? Can we send one letter and then be done and say, well, we tried and that's enough? Probably not, but we'll get to that. So what is the vortex of litigation? Well, we know what it is. The vortex of litigation is the association files a lawsuit and then loses containment, and every month gets a new invoice from the law firm, and the hourly billing goes from $500 a month to $5,000, $10,000, $15,000 a month, and there's no containment whatsoever. Hourly billing is killing the association. The reserve fund is for maintaining deteriorating assets on a predictable basis, but now the reserve fund is being sucked into the vortex of litigation, and there's no way out. So we're in the vortex. We've sued someone over the chickens, and there's no way to get out. You're sucked into the black hole. How do we avoid that? Well, let's remember that in 2025, nothing's changed from 1995 and 1985. There are three enforcement options, basically. There's a courtesy letter. Hey, we know you have chickens. They violate the CCNRs. Please come into compliance. Pretty please. We'll check back with you in 30 days. Please, please, please. That's a courtesy letter. Ignore the triple please part, but a courtesy letter is, we're not threatening legal action, but please come into compliance, or some version of that. Some of these courtesy letters are better than others. There's also a door hanger and other versions that some have been quite successful, but basically no threat, no fine, no monetary penalty, no litigation, no legal letter, just a courtesy letter. And the second option is a monetary penalty. I use this term because that's the term in the statute. We also call it a fine, FINE, where we impose this monetary penalty. And then the third option is the vortex of litigation, the injunction lawsuit. We sue someone for a court order where at the end, the judge orders compliance. The reason we call this the vortex is because it's in superior court. There's a possibility of a jury trial. It's hourly billing. The attorneys are the ones who win, no question. It's a mess. And even though I do a lot of this work, and we don't apologize for the fact that it's messy and expensive, the client ends up losing because of the cost. So let's go through a factual scenario. This case happened to me in my legal career. So here's what happened and why it got to be so problematic. The hypothetical but real thing was there was an extreme hoarder. Think of a hoarding show on TV, documentary, but the worst one you can imagine. Here in Gilbert, lives next door to an owner who is bothered to the extreme by the existence of the extreme hoarder. Now, when you say extreme hoarder, this is not just somebody who has rotting food in their kitchen. It's filled up the entire house, including a basement, and has spilled out into the backyard, filled up the entire backyard to the point where the items and the personal property have filled up the backyard from the ground to 6 feet. And in fact, a 6-foot block wall has been evened off at the top, where the neighbor standing in the backyard at 6 feet cannot see into the other person's backyard because it's leveled off at the top. You'd have to get on a ladder in the neighbor's yard to see into the other person's yard, and then it's like a flat sea of items stacked up to 6 feet. So the neighbor next door develops the belief that the existence of the hoarded items are contributing to vermin, animals, insects that travel from the hoarder's home to the bothered person's home. And that if the hoarder's home were cleaned up, the neat person's home would no longer be invaded by the vermin. Now, don't get stuck on the story. Don't get stuck on whether that premise is true or not. Don't get stuck on the hole in my story, including what vermin. Is it rats? Is it mice? Is it insects? I know that the story doesn't make a whole lot of sense as I've told it. Don't wonder too much about it. That's the premise of the case. An actual extreme hoarder next to someone bothered by it who alleges the movement of vermin from the extreme hoarder to the next door neighbor. It's actually not next door, it's rear yard wall to rear yard wall. And the person who's bothered by it, their backyard is immaculate, beautiful green grass, extremely beautiful and immaculately maintained swimming pool. And it's not hard to imagine why they're bothered by the extreme hoarder. So the bothered owner sues the HOA for failure to enforce. I mean, that's exactly what we're talking about. The HOA has not done enough. The vermin and the problem of the extreme hoarder is a direct result of failure to enforce. Exactly where we started in this webinar presentation. If the darn HOA had done its job, I would not be suffering. under the weight of my neighbor's failure to comply with the CCNRs. Because the condition of that rear yard, the condition of that home is a nuisance. It's an offensive activity. The maintenance of that home's rear yard is no less than a nuisance. Now, I challenge anybody on this webinar, it's a rhetorical question, no response required, to think about your CCNRs and ponder to yourself, do my CCNRs have a nuisance provision? Do my CCNRs have an offensive activity provision? And you will say in your mind, yes, they do. So if this hoarder were in my community that I manage as a professional community manager, and a hoarder were there with a rear yard stacked up at 6 feet, level with the 6-foot rear yard wall, and vermin were living there and escaping to someone else's yard, and they say, well, that bothers me. The association allowing that to exist is creating a nuisance for my property, and they sue the association for failure to enforce the nuisance and offensive activity provision. Could they say that sentence start to finish in the community I manage? And you would say to yourself, well, I guess when you put it that way, a person could say that sentence start to finish in my community. You could say it. I know you could. So we're all on the same page here. So in this hypothetical with the extreme hoarder, how much enforcement is enough? Because this client, now a number of years ago, sent letters. They sent courtesy letters. They imposed monetary penalties. But if you know anything about the condition, the affliction, the disorder of extreme hoarding, you know that nothing worked. It did not work to send courtesy letters. The hoarding behavior did not change. The rear yard did not, nothing moved out of the rear yard. Nothing discernible moved. The courtesy letters didn't work. The monetary penalties did not move the needle in terms of removing items from the rear yard. The association did everything except number 3, injunction lawsuit. And so the neighboring owner sued for failure to enforce. We ended up in that lawsuit. And in fact, the association engaged the Boy Scouts to do cleanups. Some progress was made, but again, not to challenge your understanding of the disorder and the condition of being an extreme hoarder, but if you do know much about it, the items accumulated again in the place where the Boy Scouts removed them. The local church in the area, connected to some folks on the board and involved in the association, the local LDS church engaged some scouting groups and others to assist with moving things out, but they were replaced as soon as they were removed. So the neighbor sued the association, and the question in the lawsuit came down to, well, Your Honor, look what we've done. We've done number 1, we've done number 2, and we have engaged community efforts to remove items. And we were moving toward litigating the issue and going to trial when there was a mediation, a settlement conference. And the settlement conference resulted in yet another cleanup where another community effort occurred and every single item was removed from the rear yard, every single item. And that was enough to resolve the case. Uh, but it was not fully litigated. So we end up in this situation where we don't really know for sure what is enough, although we do know that in that hypothetical case, the bothered owner did say his position in the case was that enough always means a complete elimination of the violation. And to him, the violation was the rear yard because the manifestation of the violation was the vermin. Enough to the offended owner, again, go back to my chicken problem. To me, if I'm bothered by the existence of chickens and roosters, I'm not going to accept that doing enough about the violation means anything other than removal of the chickens and the rooster. Sending a courtesy letter and imposing monetary penalties is not enforcement of the covenant until the chickens and the rooster are gone. I mean, if we really think about it, if the violation is the existence of chickens and the existence of a rooster, how can it ever be enough to satisfy an association's obligation to enforce, to say, well, we enforce by sending a letter and by imposing a monetary penalty if the chickens are still there and if the rooster is still there? That's hard to imagine a judge agreeing, and that's why the bothered owner in the hoarding situation is being articulate in a sense. We just kind of have to, if we're going to be intellectually honest with ourselves on the HOA side of this question, if we're going to be intellectually honest with ourselves, we have to admit that the bothered owner is being articulate when he says, you're not doing enough if the hoarding condition is still there. It's hard for the association to say that it's enforcing the covenants by sending a letter and imposing monetary penalties if the hoarding condition is still there. And my chicken example is the same. How can the association with a straight face say it's enforcing the covenants by making some attempts that were unsuccessful? We can admit to ourselves that that's a hard thing to say with a straight face in a courtroom to a judge. We're doing our job by making attempts that we have to concede have been unsuccessful. When courtesy letters are not working and monetary penalties are not working, the injunction lawsuit may work. So let's look at our options evaluation. Each one, as we know, let's look at it. Courtesy letters will work for some owners. It's probably a personality thing. This year, I will have been married 34 years to my wonderful wife, Shannon. And a courtesy letter will work on her personality. It just will. It's the way she's wired. And getting a courtesy letter from the association is going to work for her. We've received a few over the years, whether it's a weed or a trash can. When I get home from work and she says, well, we got a letter from the HOA today about this or that, we snap into action. Personality-wise, courtesy letters work for some owners. Fines or monetary penalties must be reasonable according to the statutes. When I say statutes, I mean the Condominium Act says it, the Planned Community statutes say it. I've always believed that the bigger the better. I call that the Scott Carpenter rule. I may be the only one who says that. Nobody else may call it that, but here's why. The amount has to be a deterrent. We have a lot of fine policies here in Arizona that have what I call the assumption of the innocent violation. What does that mean? Well, the board sat around a table and said, well, let's assume trash cans, and if it's left out, it has to have been accidental. The first fine, therefore, will be $25. So the fines are too low. The fine policy assumes it's accidental the first time, when in fact, the hoarding thing is not accidental. The chickens are not accidental. It's purposeful. They have chickens on purpose. The hoarding is a very serious problem when they ignore all the other warnings, and it's an affliction that has no simple solution. But motivating somebody to get rid of items that they're attached to on a deep and troubling psychological level, it's going to take more than $25 to do something about it. The amount has to be a deterrent. If the offsite RV storage is $600 a month, and my numbers may be off, I'm just trying to make a point. If offsite RV storage is $600 a month, the fine has to be over $600 a month, but I don't mean $601, more like 1,000 plus or 1,200 plus. If the offsite storage is $600 a month, the average person will pay $1 more to have it at their house. It's got to be significantly more, like double or even triple, for somebody to say, well, if it's $600 down the street, I'll pay $200 a month to have it right outside my house. I'll pay $300 a month to have it right outside my house. RV people are a certain kind of breed. They'll pay a premium over the driving down the street to get to their RV to have it right next to their house. But you have to calibrate that into the fine amount. We need to have fine policies that have different fines for different violations. There should be an RV fine that discourages people from having that at the house. And we may need to investigate what the offsite storage costs are, and double it or triple it. We've got to be thinking big here. And then we talked about the Superior Court injunction lawsuits and how they really work really well for the lawyers. It's hourly billing. It's the option of last resort. But it can be the option of last resort if the fine policy is built to be a deterrent, really built the best way to discourage violations. We've had a lot of examples over the years where, imagine a high-rise condo where the rule is no cats, but the fine is $50 a month by the time you run through the fines. And somebody says, well, I'll pay $600 a year to have my beloved cat in my unit. Well, that doesn't make any sense. We're not calibrating the fines to be coercive toward compliance. What you're basically saying is, yeah, you can have your cat. It just costs $600 a year. I'm a dog person, not a cat person, so I don't mean to pick on cat people, but basically you're telling people the fee for having the cat you love with you all the time is $600 a year. Cat people who love their cats will gladly pay $600 a year to have their cat, but you're telling people you can have your cat for $600 a year when the cumulative fine for having a cat is $50 a month. We're making that mistake. And we're doing it without even realizing it, when our fines are miscalibrated, if that's even a word. They're not calibrated properly to encourage compliance. So when we evaluate our enforcement options, this is where we are. Courtesy letters don't work on all personality types. They work on some people, but not others. Actually, I misspoke earlier. They would work on me too. They do work on me. I said it would work on my wife, but they'd work on me too. I don't want to pay fines either. I file and litigate Superior Court injunction lawsuits. Of course, that would work on me too. I don't want to be sued any more than the next person. So these are really the options, and we need to be careful about how we go about getting ourselves into these positions. And although I have made my share of fees over the years in Superior Court injunction lawsuits, it goes without saying that this is the vortex of litigation we're trying to avoid, and we can get there with the monetary policies being revisited. It's not a bad project to think about between now and the end of the year. When we do a webinar, we take questions in the chat or the Q&A. Happy to do that. If something's come up that I've said that you want to pose, happy to take a few minutes. I try to begin and end these in 1 hour or less. I've done that today. I see I've got a few questions. What if the association manager records the meeting on Zoom for her own record keeping? The device would be a managing company's computer. Yeah, this goes to where I started. Glad you've asked that. You know, that to me would be that would fit within the statute. You have to keep it for 6 months. And I don't think we could split hairs there about whether the board recorded the meeting. I think that's what the legislature was trying to capture, is that the association recorded it. The association and the board are synonymous with management company. That's what was happening at the legislature. They just used the word board for the association / management company. Even if the board has not authorized it, but the management agent just does it. I think it's all inclusive. I'm glad you asked the follow-up question. Yeah, if anybody who records it, it doesn't really matter who's in possession, if it's the board or the management company. If the management company just does it and the board doesn't know about it, I think there is a little bit of risk that the board might end up being a little irritated. I've seen that happen before. But that's a risk for the management company to take. These AI summaries that are done for Zoom, I appreciate this question. We do not record a Zoom meeting, but AI summaries do. This is a question posed again where we started. They're not accurate, but do those need to be made available? At this point, I would not assume that the AI summaries need to be made available. The statute is quite clear that it's just the recording. And oddly, the reason it's just the recording is because the homeowner who complained to his legislator simply wanted the recording because there was a recording in his HOA that he was not given access to. And so right now we're not worried about the AI summaries. A recorded executive session, assuming the exec is properly called and noticed and is discussing an appropriate topic, is still exempt from being released on request, right? Yes. Here's a good point. My association forgives all the fines upon compliance. Please address that. I do consider that to be a best practice. Associations typically do not budget monetary penalty revenue. If you don't budget monetary penalty revenue, that means the goal of monetary penalties is to achieve compliance. Because you're not budgeting for monetary penalty or fine revenue, there's no need to actually collect it. If the goal of imposing or writing a letter imposing the monetary penalty is to achieve compliance, it is widely considered nationally, actually, to be a best practice that when you achieve the compliance, you would forgive the monetary penalty because it's achieved its purpose. So I appreciate that point, and that is generally considered to be a best practice. When fines are imposed, how do you get a violator to actually pay them? That's tricky if you do want to collect the fine rather than what I just said, which is to gain compliance and then write it off. But once it's imposed, how do you get the payment? Unfortunately, because the statutes have been changed so much over the years, once it's on the ledger, if you want it to be paid, we do have to sue the person for payment, and we can no longer foreclose on the person's property for payment of the monetary penalty. We can only obtain a personal judgment against the homeowner for payment of the monetary penalty. So we do have to sue if you want someone to pay the monetary penalty and they don't want to pay it. Here's a good question. How do I, as a manager, deal with the design review committee that allows a builder to deviate from the design guidelines? The builder looks at a house next door built in 2007 with downspouts on a flat roof instead of installing roof drains as required by the guidelines. You know, a builder, perhaps it's a custom community or something like that. A builder is no different than a homeowner from a legal perspective. A builder has to comply with the design guidelines, just like a homeowner. A homeowner has to comply with design guidelines. 30 years into a community, a home builder has to comply with design guidelines. The type of homeowner, the type of home builder, whether it's a remodel or a new build, none of it actually makes any difference from a legal perspective. Everyone has to comply. I'd kind of, point to my whole presentation. We could send courtesy letters, we could impose a big monetary penalty, and because it's a home builder, I'd be thinking of like 25 grand or 50 grand. That might be coercive to a home builder. Hey, there are design guidelines. You can't just look at the house next door. Here's a $50,000 monetary penalty. It's a little tongue in cheek, but I'm dead serious. Big monetary penalty. Now, one of the problems that we have when I say things like that, people think I'm kidding. I'm not kidding at all. With a home builder, we do really big monetary penalties. At least that's the Scott Carpenter rule. Where we run into trouble is we have clients, communities, where we have an existing fine policy that makes it hard to do what I just said. Big, gigantic fines for big, gigantic violations. And then we look back at the fine policy and realize, well, it's going to be hard to do that because as soon as we do, then the builder's going to pull out the fine policy and say, well, I was entitled to 2 warnings and an opportunity to cure before you can do that. So, Dave, I think I would look at a gigantic big fine as a first step before looking at an injunction lawsuit. Is the board obligated to provide a live committee that hears rebuttals of the violations of persons, or can the rebuttals be issued in writing only? I've changed my position on this. Monetary penalties can be imposed after notice and opportunity to be heard. That's the language in the statute. There are many associations and management companies that have correctly noted that fines can be imposed after notice and opportunity to be heard. And I have worked with a number of management companies and association clients over the years to create a in writing only opportunity to be heard. So I am in support of this idea that these fine appeals do not have to be live free-for-alls, court hearing type tribunal hearings, and convert them to your written opportunity to be heard is due 5 days before the next board meeting, and leave it at that. On a fine appeal, it's not an appeal, it's an opportunity to be heard. Hey, homeowner, your monetary penalty is, I'm going to again say something silly to make a point. Your monetary penalty is $5,000. You have an opportunity to be heard. It's in writing. It's due, I'm looking at a wall calendar. It's due May 28th to be considered at the June 10th board meeting. Simple as that. What if you're a large rural subdivision with lots of 2 to 40 acres? There's one extreme violator among 140 owners. That's about statistically correct. The problem is that there are many violations on this 10-acre property. We can't go on to or see onto the property to check because of fences, trees, etc. Limit visual examination from adjoining properties. How can we approach this without just foreclosing? It's tricky. My guess is that perhaps the CCNRs, perhaps, I don't know, I'm guessing that perhaps the CCNRs do have an inspection right. I don't know. It's I'm guessing if somebody with that many violations would consider a drone to be a trespass. I don't know. But there's always room to be creative. You could ask him to allow an inspection. Um, we could sue him for the violations we can see and then ask the judge in that lawsuit for a court order to allow an on-property inspection. But Bill, these are good questions and I can't answer them fast enough, I suppose. Are meeting minutes required in executive session and do they have to become public or just the board? Executive sessions do require minutes, but they are limited to the board. The association members do not have access. Another question, we do not have to have a hearing with the board on fines. It's just an opportunity to be heard and it can be in writing. Yeah, back to this custom builder. It is a custom builder for later resale. All right, couple final questions. I'm over time. If someone refuses to remove an item like a basketball hoop from a driveway, what's an appropriate course of action beyond a letter? Neighbors object to the sounds of playing on the street. The association maintains the driveway, but it is considered a limited common element for the exclusive use of the owner. This is a tough one because people take sides pretty quickly about basketball being normal kid behavior, and people take sides pretty fast. I've taken a lot of pride over the years that no matter what the behavior is, I can find a violation pretty easily in the documents. This one could be an offensive activity or a nuisance, but I'm also sensitive to people taking the side that kids will be kids. We've got to be careful that the HOA doesn't look like it's trying to keep people from normal childhood behavior. I'm a little nervous about that, but I'm not sure from the question here who's actually in ownership of the area. But it's something we could definitely take a quick look at, but I'm not sure entirely where we'd end up on the deal. Well, happy to have done this today. It's a good exercise in remembering that enforcement is a mandatory duty and our options, we do have options. We could get caught in the vortex kind of easily, but thank you all for participating and thank you for your questions. Good luck out there. It's never easy because people have competing expectations. And I'll see you for our June seminar. I forget when that is exactly, but it's on our website. And looking forward to our legislative update on July 15th. Thank you and have a great day. We're here if you need us. Bye.